it follows that whatever modifications, amendments, or exceptions that may become necessary, either to Article 370 or any other article in the Constitution of India in their application to Jammu and Kashmir, are subject to decisions of this sovereign body. Since a good deal of confused thinking and uninformed criticism is indulging us in the interest of, I would like to point out here that the Constitution has confined the scope and jurisdiction of the Union powers to the terms of the instrument of accession, with the proviso that they may be extended to such other matters also as the President may by order specify with the concurrence of the Jammu and Kashmir Constituent Assembly. The special problems facing the state were thus taken into account, and under the Constitution, the relationship approximated to that subsisting under the instrument of accession. The Constitution of the Indian Union therefore clearly envisaged the convening of a Constituent Assembly for the state of Jammu and Kashmir, which would be finally competent to determine the ultimate position of the state in respect of the sphere of its accession, which would be incorporated as in the shape of permanent provisions of the Constitution. This briefly is the position which the Constitution of India has accorded to our state. I would like to make it clear that any suggestions of altering arbitrarily the basis of our relationship with India would not only constitute a breach of the spirit and letter of the Constitution, but it may invite serious consequences for a harmonious association of our state with India. The formula evolved with the agreement of the two governments remains as valid today as it was when the Constitution was framed, and reasons advanced to have this basis changed seem completely devoid of substance. In arriving at this arrangement, the main consideration before our government was to secure a position for the state which would be consistent with the requirements of maximum autonomy to the local organs of state power, which are the ultimate source of authority in the state while discharging obligations as a unit of the federation. Then will us kindly come PDF 648. This is Mir Qasim's statement on 10th November 1952. And this is exactly what I've been submitting before your lordships from day one. A unilateral executive decision cannot change the terms of a relationship which are constitutionally embedded in Article 370. Well, as PDF 648, page 2007. This speech was given by Mir Qasim on 10th of November 1952. And the statement of the Sheikh Mullah, that discussion on his statement continues. In the middle of that paragraph, starting, it is said that the accession of Kashmir with India should be, as far the statement is concerned, there can be no denying the fact that it should not be a dynamic in the sense that we give up our principles. On the contrary, accession should help us in achieving ideals and preserving our autonomy, except, of course, in the objects we handed over to India. Our assembly is competent to make laws and decide the issues, if any, since we are enjoying complete autonomy. We can even frame and amend our constitution. In this collection, we have application under connection. It should be with the application order of 1950 of the Indian Constitution. According to this order, all these powers do not vest in the state. Now, the next is important. We want to develop Kashmir according to the program of New Kashmir. Some people say that it is just possible that in future Kashmir may also become a part of India like any other state and get merged with it. In that case, our eternal economy will be reduced to naught and residuary powers will be snatched from us. In this connection, I will submit that the thinking of such people is morbid. These are the vested interests which create such misunderstandings. The representatives of the government of India have not kept any time limit for these residuary powers. This is important. That's why, Malas, 370 talks about instrument of accession and the items in the concurrent list, but doesn't talk of list 2, which is the residuary powers of the state. Therefore, there should be no room for such doubts. We have acceded to India with a definite objective, and I am sure the objective will be achieved. Some interested persons are creating misgivings as regards the autonomy and say that Kashmir has been granted autonomy simply to benefit its Muslim population. But this is a baseless allegation. If the people from outside are not given the right of acquiring property in the state and getting recruited to state services, then it was not the Muslims of this place alone would get benefit, but all communities will also get benefit. Then let us kindly come to the social system which will be set up according to the program in New Kashmir will provide equal opportunities of development to all citizens of the state, be they Kashmiris, Ladakhis, or Dogras. Now, let's skip the rest. PDF page 694 now.
Formulate, now that we've seen the speeches, we'd like to formulate the principle which
the principle is, Malas, that an executive act of the Union of India cannot alter unilaterally provisions of the Constitution of India as applicable to the state of Jammu and Kashmir. That's the central.
Cannot alter unilaterally.
Yes.
The provisions of the Constitution
of India as applicable to the Jammu and Kashmir. Including getting rid of the special status given, acceded to by the Union, by the Government of India, and by Parliament in enacting 370 of the Constitution. That's the submission.
Says it's an executive act.
I'll say 356 is executive, 367 definition is executive. These are all executive acts. Parliament came into the picture when the changes had already been done through executive acts. We're challenging that.
As you argued, the process was wrong.
Yes.
Whatever was done.
Yes.
That is, the Parliament did it.
No, Parliament accorded approval to the executive acts which unilaterally changed the Constitution as it was applicable to the state of Jammu and Kashmir. That's the central question that your lordships will have to decide. Could Parliament have, could the Union of India have done it?
Is it your case that the Parliament could have done it?
No, not at all. Well, that also I will answer. Well, let's kindly see. Ultimately, this was a political decision taken in the context of the situation then prevailing. Right? And the complete abrogation of Article 370 must also be a political decision. Well, as your lordships will remember Brexit, what happened? In Brexit, what happened? There was no constitutional provision seeking a referendum. But when you want to sever a relationship which has been entered into, you must ultimately seek the opinion of the people. Because people are central to this decision, not the Union of India. It goes counter to the very grain of Article 370.
Mr. Tribble, in a constitutional democracy, seeking the opinion of the people has to be through established institutions.
Agree?
Right? So long as a democracy exists, as it does, in terms of a constitutional democracy,
yeah,
any recourse to the will of the people has to be expressed and sought in terms of established institutions.
I agree. So
There's
either you do it,
so
either you do it.
You cannot envisage, therefore, a situation like a Brexit type referendum.
Yeah.
That's a political decision which was taken by the then government.
Yes.
But Within a constitution like ours, there's no question of a referendum.
But this is a political decision that they have taken by unilaterally through an executive order, changing definitions. This is not some constitutional decision. That's what your lordships, supposing your lordships were to say that they can change the definition, or your lordships were to say.
But therefore, the ultimate question is whether the constitution does or does not interest that authority.
That's correct. That's all that I'm asking, Miller. I'm not asking for anything more.
And which in turn depends on whether 370 is construed as you say, a permanent feature, irrespective of the terminology used, because that is in the context of the changes till the Constituent Assembly was there, or is it something which is capable of being?
Well, let me see. That's a much higher level, Malas, to which I'm not, in fact, arguing that today. Malas, whether it is permanent or it is temporary, let's forget about it. The central question is, can the Union of India, in this manner, terminate that relationship that is constitutionally recognized in Article 370?
You understand?
It may not be permanent. It may be permanent. It may not be. You may change it. You may. You may have.
In the context that that was the argument earlier. So we have come to the next argument, which is the manner in which it is done.
That's right.
Is flawed accordingly.
It's absolute. It's a fraud on the Constitution itself, according to me. It is politically motivated. It is a political act. These executive orders are political acts. They're not constitutional acts. That's my submission. And whether it is a permanent feature or a temporary feature is really, at the moment, not an issue. The reason why it's not an issue is maybe there is a constitutional way of doing this. I'm not addressing that. Nor have they resorted to that constitutional methodology. If they resort to it, it will be tested in a court.
And on the process, you said last time that, first, the Section 92 power was vested in the governor,
Yes.
independent of the Council of Ministers. Step
36,
2,
38,
right.
and
Step
92.
2, right. Step 2, the Legislative Assembly is dissolved by the governor under Section 53 without aid and advice.
Yes.
3, the proclamation is issued under Article 356.
Yes.
You said that the object of the proclamation under 356 to eventually restore democracy.
That's right.
And not the decimation of democracy.
Right.
And then finally, we saw the amendment of Article 3 in the presidential notification.
That's right. That's
So
also an executive act.
all these 4 steps, according to you, were constitutionally flawed. There was no provision for these 4 steps because you've essentially taken away the powers of the State Assembly and exercised them under the garb of 356. That's the submission.
That's right. Absolutely, I'm deeply obliged to your lordship. But I just want to read one other.
Only one last thing which I wanted to ask you. You've made your point on the process which was followed. They will have to answer it. On the proviso to clause 3 of 370, is there something ultimately that happened in the Constituent Assembly which sheds light on which way the Constituent Assembly was inclined to go?
Yes.
Because we are reading individual speeches. What happens thereafter at the end of this process?
Well,
in 1957.
The Constitution was adopted in 1957
Yes.
by the legislature of Jammu and Kashmir. Between 1951 and 1957, they could have determined or terminated the essence of Article 370, abrogated it themselves, and said, there's no need for this Constitution. We want to be a state, a part of India, like any other state. That is why 370 sub-article 3 referred to the decision of the Constituent Assembly. That decision could have been taken, but my lord asked me the question, well, now that there is no Constituent Assembly, how will this happen? If it were deemed to be a temporary provision. That's what my lord put to me. Right?
So your argument would be really, I mean, if I can put it that way, that the proceedings in the Constituent Assembly of the state of Jammu and Kashmir would indicate a reaffirmation of the arrangement under Article 370 as a long-term arrangement.
That's right.
So that the 3 options that Sheikh Abdullah spoke about, namely either of joining Pakistan, acceding to India, or remaining independent, they gave up the first and the third option.
That's correct.
They decide that the ultimate decision was to stay within the dominion of India, but subject to the safeguards of 370.
That's right.
And therefore, according to you, 370 assumes a permanent character, irrespective of the nature of the provision which is envisaged in the Indian Constitution.
And that's what Sheikh Abdullah said in his speech, that look, this relation...
That still begs one question.
Yeah.
as to whether it was enough that the Jammu and Kashmir Constituent Assembly proceeded on that basis. Put 370, which was envisaged to be a temporary provision, be converted into a permanent provision merely by the proceedings of the J&K Assembly? Or was there some further act required from the Indian Constitution, either in the form of a constitutional amendment, by virtue of which 370 would cease to have a temporary character but have a permanent character, in implementation of the wishes of the Jammu and Kashmir Constituent Assembly?
Whereas Government of India never expressed a contrary opinion throughout.
But didn't it have to take place through a process of amending the Indian Constitution itself?
No.
To convert the character of 370?
All right. Well, now your lordships are again going back on the issue of temporary nature. That temporary nature is not part of the Article 370. It's not part of it. It's not a part of 370, Madam. In fact, Muzaffar Beg says we didn't even know about it. That's why I want to read Muzaffar.
Mr. Sibal, there are two ways that we could really lead into this discussion. One, that though placed in Part 21, Article 370 was never intended to be a temporary provision. That's one layer of reasoning, which is what you're advancing. Two, that though it was temporary, the reason why it was placed in a temporary provision of the Constitution was pending the decision of the Constituent Assembly of Jammu and Kashmir, and therefore it was given the character of a temporary provision, because the views of the Constituent Assembly of J&K were still to be elicited.
Right.
Third, that's the second argument. We accept that for the purpose of hypothesis. The difficulty, of course, which we have to face is this. Assuming that was why it was placed as a temporary provision, because the views of the J&K Constituent Assembly were still to be elicited. And you also take your point that the J&K Constituent Assembly decided to accede to India and reaffirm the accession to India subject to the safeguards of Article 370. Is that sufficient in itself to convert 370 into an unamendable or untouchable provision?
Let me assume, Malaj, that it is not.
Or was something more required by a parliamentary intervention in India post-independence to convert that which was essentially temporary into a permanent provision?
Let's assume, Malaj, that it is amendable for the sake of argument. Then, Malaj, how is to be amended? The Constitution must provide a solution, no, Malaj? I'll assume, Malaj, for the moment that it is amendable. Then how does the Constitution of India must provide a solution for that?
Once we concede, Mr. Sibal, that concede in the sense for the purpose of the hypothesis. We're not putting anything in your mouth, not at all. So I don't misunderstand that. Once we accept the fact that 370 is subject to the amending power under 368, then equally 370 provides for a modality through which 370 itself would come to an end.
Well, let's see 370 then, Malaj, and see what modality is. That modality can't be to convert a legislative assembly into a constituent assembly by definition through an executive act under 367(1). Then, Malaj, we have to find the modality within the Constitution, not outside it, not vested in an executive power of the Union. That cannot be. So if your lordship puts to me, and rightly, that something more had to be done under the Constitution of India, we'd like to know what is that something more.
But 370 bracket 3 itself specifies the conditions in which the abrogation can take place.
Which is the Constituent Assembly it must be on the recommendation of the Constituent Assembly, so it gives the solution. That is in line with the federated nature of this provision. This is complete federation, because we are quasi-federal other states. But these are purely federal Jammu and Kashmir, because the residuary power vests in the state. So if you say, that C70 sub-article 3 provides that solution, but that is provided, certainly, but upon the recommendation of the Constituent Assembly.
And therefore, according to you, the power is completely lost once the J&K Constituent Assembly comes to an end.
Let me even not go that far. I'll assume that there is some power available. It may be 368. Let's say, it's hypothetical. We're not concerned with it.
No, Mr. Sibbal,
Maybe
no,
it's-
no, when you argue, then we'll have to take one. 360 is power to amend the constitution. That's certainly there.
Yeah.
Now, when we look at 370 clause 3, now the issue would be whether 368 power is still available to amend the constitution.
But your lordship is not concerned with it in this matter.
No, it is. It's very, very crucial. Because once we accept the fact that Parliament as a sovereign lawmaking body has the power to amend everything, including 368.
Yeah.
370.
Sorry, including 370.
Yeah.
Then any amendment of 370 may be subject to criticism on the ground of morality, but not power.
No, but it's not an action.
Maybe it's a political argument, but not a power. It's not an argument of constitutional
This is
power.
not action under 368. Your lordship is not going to hypothetically say this is an action under 368 when 360 has not been invoked.
But then likewise, the exercise of power under 370 bracket 3, can it not be then criticized? It's a question of criticizing it as a political criticism. But is it an argument of the absence of power?
Where is that in 370?
And the
that
court
power?
the court is concerned with either the existence or the absence of power, right?
Not that I should ask your lordships, where is that power in 370 that says that 368, you can do it under 360?
So 368 is the power to amend the
But
constitution.
we are not, are we concerned with that here? I'm sorry, Manoj, you require 2/3. You represent.
There are independent avenues. You have the power to amend.
Manoj,
You have the power within 370 to abrogate.
But Manoj, in that independent avenue must conform to the provisions of the Constitution. Well, an independent avenue derogates the provisions of the Constitution, no avenue at all.
Mr. Sibbal, for the timing, if we ignore the proviso to clause 3, in fact, the clause 3 itself, independent of the proviso, gives the power to the president itself to abrogate 370. If we forget about the
Sorry.
proviso.
I'm sorry to say that, Manoj. I'm really
Just
sorry.
read
There is a
just read it
proviso.
once again. Just read
You
it once
can't exercise that power without the proviso.
No, the proviso is something different. We are examining the proviso independently. But independent of the
That-
proviso,
Clause 370 comes into play on the recommendation of the Constituent Assembly. Your lordship is putting it the other way around. It comes on the recommendation of the Constituent Assembly that the president will exercise power, not the other way around. That's why I said you can't even initiate a bill. Your lordship will remember that. You can't even initiate a bill. Forget about anything else.
Another problem is that then we would be redrafting the substantive part of clause 3 to postulate that the power under the substantive provision of clause 3 can be exercised so long as the Constituent Assembly of J&K is in existence. In which case, will a proviso not swallow up the main provision?